Hey everybody, we're going to start our second section of Unit 4, which is looking at the court in action and specifically how the court, comes to view cases, how they make decisions, and various philosophies that they abide by as they interpret the Constitution. So your goals for this video are to describe the process of appealing a case to the Supreme Court. So basically, how does a case make it there? Compare judicial activism and judicial restraint, and explain how the exercise of judicial review in conjunction with life tenure can lead to debate about legitimacy of the Supreme Court's power. All right, so choosing cases. Remember from notes 4.1 that the Supreme Court has both original and appellate jurisdiction, but it mostly is going to use appellate jurisdiction. It will only exercise original jurisdiction in very rare cases. And something to note is that the Supreme Court decides which cases it'll hear. So what happens is, we know we've talked about what appellate jurisdiction means, right? This review of a previous court's decision. A losing party will file a petition to the court, the Supreme Court. And in that petition, it's going to contain a brief, basically a summary of why they think the lower court made an error, in what way they erred, in what way was the Constitution potentially violated, among other issues. Now, the Supreme Court is going to review this petition to determine if the claim is worthy of being granted that appeal. And at least 4 of the justices on the bench must agree to accept the case. And we call this the rule of 4, right? So it's not a majority, because they wanted, minority cases, things like that, to have a chance to be heard by the court. Now, if 4 justices agree to accept the case and hear the case, the court will then grant what is called a writ of cert. You don't have to worry about pronouncing this word. We pretty much call it writ of cert. And basically, a writ is an order by the higher court to send records up for review. So the higher court, the Supreme Court, will ask the lower court, wherever it was last, whether that's the circuit courts of appeal, the state Supreme Court, to send up records, right? What evidence did they have? What were the legal, what was the legal reasoning behind the case? We want all of that information so that we, as the Supreme Court, can review it. And at the core of this, guys, yes, the Supreme Court decides which cases it'll hear. Only very few cases are accepted, like less than 1%. The court receives thousands of petitions for appeal. They'll only select, I think on average, it's 80 cases per Supreme Court term. And they receive thousands of them. Okay, so it's very, very unlikely that cases will be heard by the Supreme Court. That's the most likely option. Now, some things that do influence whether the court hears a case. The Supreme Court is more likely to hear a case if there are a couple of things. Lower courts have invalidated or conflicted with federal law. Decisions have been split in lower courts, so different courts have made different rulings on the same issue. If the case presents a new constitutional question, right? If questions that have never been ruled upon come before the court, that's likely to draw attention to the court, because they want a chance to, kind of flesh out what the Constitution means. And then also, if the case is of national importance. I mentioned in our last set of notes that, the Supreme Court is going to be more likely to hear on cases that are important of the day. But also, on the flip side of this, public opinion matters, right? So yes, right now, the court is hearing cases about immigration, about COVID restrictions, right? About election results, the Electoral College, abortion. Those are all things that are of national importance. But public opinion does matter, right? The court is aware that cases, the decisions that they make that might go against public opinion will not be implemented, right? Remember, the court is insulated from public opinion. They're not voted in, but the people that are responsible for enforcing the court's decisions are, right? Your executive branch, your legislative branch. And they know that if they're ruling or listening to cases that are going to go super against public opinion at the time, they know that that ruling is not going to be implemented. And probably that might, influence whether or not they decide to take a certain case. Now, when it comes to actually making the decisions itself, it looks a little bit different because this is not usually a trial court. Some things stay the same. There are attorneys on both sides will submit briefs, which a brief, guys, is like, again, a summary. They're going to submit a written legal argument for the court. Now, there are no witnesses, there are no jury when the Supreme Court is listening. Attorneys will include a summary of the cases, their legal argument, why they think the court should rule a certain way. And then this is where amicus briefs will be submitted by outside opinions like interest groups. Right. The NRA, ACLU will submit amicus briefs talking about, their interest and why they think the court should rule a certain way as well. Those friend of the court statements. Now, oral arguments may be made in a case, right? The attorneys may actually have a chance to get up and discuss. However, there are a couple of restrictions on making decisions in the Supreme Court. No video is allowed. Like, none of these sessions are ever recorded. The public is allowed to sit in, however, and that creates some transparency. And the justices will then discuss and vote in private in order of seniority. So the Chief Justice will begin, and then, the longer you have been on the court, the further in line, or the closer in line, I guess, to the beginning, you get to discuss and then make your final vote. So this is typically what we see. This is a little bit of an older image. As you can see, Ruth is in here as well, and Justice Scalia, who we'll talk about later. But this is the type of image you'll see from the Supreme Court. There are no cameras, no photos. It is usually just artist rendition of those sitting in on court proceedings. Now, once the Supreme Court has met and they've discussed, they will then vote. And in our past, when we were talking about like the Marshall Court, Marshall kind of demanded a unanimous vote. He wanted his Supreme Court to be unanimous in its decision to strengthen its image, right, and its power. But we've shifted away from that as courts have gone on, and now all that is required is a majority. So you'll see things like 5-4, 6-3, right? That is totally fine. That is acceptable. And whatever the majority says is how the case is ruled. So when a decision is made, right, whatever side it must be, the most senior justice is going to write what is called the majority opinion. And what that does is it sums up the case, it says what the court's decision is, and then it gives its legal rationale. Okay, that legal rationale is the judicial branch's contribution to national law, right? This is basically saying, this is the decision, right? This is what happened. This is our decision because this is what the Constitution says. This is how we have interpreted the founding document. So as we'll see, this is kind of comparable to a statute from Congress or an executive order from the president. This is their contribution to national law. Now, there are a couple of other opinions that are also created when the decision is made. There is then the dissenting opinion. And the dissenting opinion is written by justices who vote against the majority. So they do not agree with the majority. They were the 4 if the case was 5-4. This allows the justice to explain their legal rationale and send a message to the community. Now, this does not contribute in any way. It's not legally binding in any way, but it does give those dissenting or disagreeing judges, a chance to explain why they were thinking the way they were, and to send a message to the legal community that they might use in future cases. And then we also might see concurring opinions as well. Concurring opinions are written by those who voted with the majority, but they might have a different reason as to why they voted for the majority. They might have a different legal understanding of the case that pushed them toward the majority. So if they disagree with what the majority says, but they still wanted to vote majority, that's when they would write a concurring opinion. All right, so some things that go into making decisions. The court, when they rule, and especially with these majority opinions, what this does establishes what is called a precedent. And that is what it sounds like. This is how a similar past case has been decided. These rulings, when a ruling establishes precedent, it establishes a legal principle and a logic that judges will use in similar cases. So this kind of leads into the phenomenon or the principle of stare decisis, which is Latin for let the decision stand, right? The idea of precedent is if you have a similar case that's been ruled on, you should probably rule similarly, right? You should be bound to that precedent and decide that new case as, similarly to how the previous one was ruled. Being bound to precedent when making a ruling in a similar case. And something to note, this is important, so I would like star or highlight or underline this. Rulings by higher courts bind lower courts to the same ruling. So lower courts must follow the precedent that is of the highest court. And that's why the Supreme Court is the end of the game, right? Whatever the Supreme Court rules, that's final. Now, an example of this, just like if we're not looking at the Supreme Court, let's say that a U.S. district court receives a case that parallels an already decided case from the circuit level. And that can be anything from abortion to education to immigration, right? This idea means that the district court is obligated to rule in the same way because they are bound to the ruling that was made by the higher court, that circuit level court. Okay. This establishes continuity and consistency in law. And my question for you guys, I want you to pause and answer this question. How? In what way does precedent and this idea of stare decisis, letting decisions stand, binding lower courts to higher court rulings, how does this establish continuity over time and consistency over time? So pause, answer that question, and then return to the video. All right. So remember, as I just said, yes, the Supreme Court is the highest authority, but that doesn't mean that their decisions are always, without a doubt, final, set in stone. Courts may and do, this is important, reverse, revise, and clarify earlier rulings. The composition of the court changes because seats become vacant. Presidential appointments, right? Whoever is in charge of the presidency at the time can appoint people to the court, and that can lead to changes in ideology of the court over time. So, we have seen liberal or more liberal leaning courts, and currently we have what you can consider a more conservative court. And those different ideologies can lead to overturning of some precedents, right? So Brown versus Board of Education and Plessy versus Ferguson are some pretty big examples here, right? Plessy versus Ferguson, as we will see, is the case that establishes separate but equal. And as we move through time, as societal issues change, as the ideological makeup of the court changed, we then see the reverse of Plessy versus Ferguson. They reversed that decision and said that separate but equal and segregation is not constitutional. And that's where we get Brown versus Board of Education. So the ideological makeup as the court became more liberal leaning in its ideology led to a reverse of a previous court case. Now, remember that one of the negatives or drawbacks or limitations on the Supreme Court is the idea of implementation. The courts do have to rely on the other branches, states, and officials to enforce its rulings. That is a check on the legislative branch, essentially. Right? Like the court is deciding what the law is, what the law says. They're interpreting the Constitution and striking things down as unconstitutional or not. However, you have to rely on the executive branch and Congress to follow through with it. So, for example, right, we see in Brown versus Board of Education, desegregation, right? Separation by race is no longer constitutional, but that was not really enforced by the other branches, the states, and public officials. So, for example, 10 years after Brown was ruled, only 1% of Southern schools were desegregated, right? So, yes, the court ruled that that was unconstitutional, but it did have to rely on other pieces of the government to carry that through and implement it. And that just was not happening at a very fast pace, right? And that's why eventually we do see some officials, right? This was Eisenhower who federalized the National Guard in Arkansas and, took the steps to enforce that judicial ruling and allowed the Black students to enter into Little Rock Central High after the ruling of Brown versus Board of Education. All right, so judicial philosophies influence how they interpret the Constitution. And the controversy, the legitimacy of the court, right, is what role should the Supreme Court take? So I have another reflection question for you guys. Justices are supposed to be independent and above politics. What do you think this means? And you can even think about, why did the framers want this to be the case? Okay, so take a moment, answer that reflection question, and then return to the video. All right, so we spent the last couple of days talking about judicial review, giving the Supreme Court the right to determine the law, interpret the Constitution, and as a result, check the other branches of government from acting unconstitutionally. This is that main check that the Supreme Court has on the other branches. Now, because of judicial review, because the court has this power, there have been debates about the exercise of judicial review. And those debates have emerged, right? To what extent should the court exercise judicial review? How frequently? Things like that. And that has become kind of a debate between judicial activism and judicial restraint. So one of the philosophies of judicial, decision making is judicial activism. And judges participate in judicial activism when they strike down laws, reverse public policy. Literally think about it like they are taking action. This can be liberal or conservative. Right? Examples, there was a case, Lochner. This was a more conservative ruling in terms of being activist, because it was a law about unions and wages that the court struck down as unconstitutional. But then the court can also be actively liberal as well, with example Roe v. Wade. Sorry, that was a note for myself. You can ignore that, page 202. But Roe v. Wade, right, was an activist case that struck down a conservative anti-abortion law in Texas at the time. And we'll look into that later in the class, but just know that it doesn't have to be one or the other. Just because courts are striking down laws doesn't make it, liberal or conservative. It can be both. A judicially activist judge views the Constitution as living and active. So they're often called living constitutionalists, which is fun to say. Right? And their whole thought process is, in order to endure, in order for the Constitution to stay our foundational document that is relevant, the Constitution should be interpreted to change with society and to adapt and to adjust to the times. Right? The framers in this side, people argue that the framers had no idea that we would be facing issues that we are today. So we do need to be a little bit more flexible in our interpretation, adjust it with society to keep it relevant. Another example, right? Guys, we talked about this before, but this is an example of judicial activism, overturning Plessy versus Ferguson with Brown versus Board of Education, right? This would probably be considered a more liberal action of judicial activism, right? Plessy versus Ferguson set up legal segregation around the country, but Brown versus Board of Education struck that down. Now, the critics of judicial activism, and there are many on the court even to this day, and that's just their philosophy, which we'll talk about next. Critics say, is this democracy? Is this interpreting the Constitution kind of loosely and more flexibly democracy? Their argument is, aren't the representatives, the legislators, isn't Congress, who is elected by the people, supposed to create policy? And a lot of people view, who disagree with judicial activism, they believe that this action of, striking down laws, interpreting to adjust to the times, they view that as almost legislating from the bench, which again brings into question, how democratic is that? Because the judges are not elected by the people. They are not directly connected to any public opinion whatsoever. Now, on the flip side of things, we have judicial restraint. And judicial restraint is also called strict constructionalist or originalists. And judicial restraint, if a judge practices judicial restraint, usually they're operating under the idea of original intent. And that's kind of what it sounds like. This is the idea that the Constitution should be viewed according to the original intent of the framers. So, however the framers wrote it in the Constitution, that is how we should interpret it. And the idea behind this is no, we should not take action frequently. If we see that there are laws or policies that need stricken down, we should only declare laws unconstitutional when it clearly and directly contradicts the Constitution. We will be listening to in class the words of a previously passed away, he's passed away now, Justice Antonin Scalia. He was a strict constructionist who practiced judicial restraint in his time on the Supreme Court. So we'll listen to him talk about this idea. Now, the job of a strict constructionist or originalist, the job is seen as more passive to apply the law as it stands, because otherwise, as I mentioned before, it could be considered legislating from the bench, which is potentially seen as undemocratic. And judicial restraint as a result, right, because they're not, overturning previous laws, declaring them unconstitutional, they're going to make heavy use of precedents, right, let the decision stand, stare decisis, and going off of what similar cases have already been ruled. Now, critics say, and some of you might have been thinking this as you were writing and taking notes, critics are going to say, well, how do we know what the framers meant, right? Because the framers were, elite members of society. They were white. They were in their middle ages, like they were middle-aged, right? How could we know what the framers meant? How could we know, like, what they intended for the country to become? And society has changed as well. And that's then the argument of those who follow judicial activism. All right, guys, so your goals were to describe the process of appealing a case to the Supreme Court, compare judicial activism and judicial restraint, and explain how the judicial or the exercise of judicial review in conjunction with life tenure can lead to debate about the legitimacy of the Supreme Court's power. So what I'm going to have you guys do, I know in the past we have responded to these questions. Remember that we are now switching to uploading or showing me in class photos of notes. So if you know that you will be in class, make sure that your notes are completed thoroughly and completely. I will come around and check. And then if you know that you will not be in class on the day that these are due, make sure to upload your photos of your notes to the Google form that is linked here as well as in Google Classroom on the day that they are due in order to receive full credit. So let me know if you guys have any questions, and we will deep dive into some of these cases and philosophies when we see each other in class. See you later.